And now, I would like to introduce you to the keynote speaker of this international conference, Professor Stef Bartman. And a few words, of course, about our distinguished guest, Professor Bartman. Professor Bartman is a professor of company law at the University of Leiden in Netherlands. He's attorney at law at Bartman Company Law in the Netherlands, co-managing director of the CCL, the Center for European Company Law, and initiator and editor-in-chief of European Company Law, ECL journal, as well as of the CCL book series, published by Kluwer Publications. He's a prolific writer in the area of European and Dutch company law. Professor Bartman is the initiator and co-author of a widely used book titled About the Corporate Group. I'm sorry, I cannot read the Dutch title, Van Het Concern, which contains an elaborate survey of group company law in the Netherlands. He frequently lectures on research developments in corporate law, not just for Leiden students, but also for practitioners and judges in training. Stef is a well-known commentator of judicial awards published in several leading Dutch law journals. Professor Bartman is a pioneer of European company law. We cannot think of a single person more qualified to address the current audience. Professor Bartman, the floor is yours.
Thank you very much, Thomas. Good morning to you all. You're doing me too much honor, Thomas. You know very well that in my practice and in my research, I hardly focus on European company law. It's much more substantive Dutch law, but I'm doing the best I can. And I can assure you that as of next year, when I will retire and I assume the status of emeritus professor, I will focus more even on European company law. So you haven't heard the last thing of me on that front. Okay, ladies and gentlemen. The 10th EU directive on the cross-border mergers, the so-called CBM directive, has been in effect for 10 years now. When it first entered into force back in 2007, it inspired the Center for European Company Law to devote a conference to this matter in Utrecht, and Thomas, you attended that conference here in the Netherlands. And so your idea of, let's say, host a conference here in Nicosia, or Lefkos, as you say, was really a brilliant idea to celebrate the second lustrum of this very important directive. So in this speech, I will address two aspects of the CBM directive that, in my view, deserve some more attention of the European legislator. I will first draw, and by the way, I did send you some sheets, but it's not important.
I have them over here.
There are only two substantive sheets, so.
A moment.
Huh. It gives me a chance to flag out the logo of the Leiden University,
yes,
of course. So.
Of course.
So that's the first one. So I will touch upon two topics. The first topic that I would like to touch is some more attention for what I call the EU corporate law border. There's a lot of talk about the protection of the EU physical border, but I think there's also, or there should be, an EU corporate law border, which should be more protected, in my view. And the second topic is protection of the rights of the minority shareholders involved in a cross-border merger. So, which brings me to the third sheet already. It's going fast. I assume that, like many other countries, Cyprus has a keen interest in attracting investors from other EU jurisdictions by facilitating their efforts to become Cypriot companies, the so-called inbound legal merger. Of course, it also works the other way around. Cyprus companies can form outbound mergers with companies from other EU countries and so assume such other nationalities. Rumor has it that Cyprus immigration law, of which I know nothing about, makes it relatively easy for non-EU citizens to assume the Cypriot nationality and enjoy EU recognition. And I wondered, is this similar for non-EU companies? So that's what I would like to find out. And Thomas and I, we had some discussion about this. He knows all about Cypriot legislation, of course. I know nothing about it, so I fully depend on your input on that, Thomas. A recent study, I have to drink something, otherwise I'm going to do an impersonation of Theresa May, which I don't want to do. A recent study on the law applicable to companies shows that Cyprus is one of the few EU member states, besides Belgium, Malta, Portugal, and Spain, that on the basis of specific legislation allows not only EU companies, but also non-EU EEA, so including the European area companies, to transfer their registered seat to its own jurisdiction. Such overseas company can then be re-registered as a Cyprus company or merge with a local Cyprus entity and thus become a full-fledged Cyprus company. As a consequence, fulfilling just a few simple administrative requirements, for instance, a Turkish or a Russian company could easily transform itself into a Cyprus company, provided that the national law of the Turkish companies and Russian companies allows that, of course. And then, by making use of the CBM directive, enjoy freedom of establishment and assume the corporate clothes. That's going too fast. Right. Now it's completely gone. Have a great conference again. Well, I sure wish you have. And now, one, sure that, okay. So as a consequence, fulfilling just a few simple administrative requirements, another company from abroad could easily transform itself into a Cyprus company and then enjoy the freedom of establishment and further on travel into the European area by making use of the CBM directive. As I said, this is allowed under the specific laws of just a few EU member states, including Cyprus. However, in practice, voluntary inbound reincorporations by way of transfer of seat of non-EU companies are also allowed in some other member states without any specific legislation. And such goes for Luxembourg, as I'm informed, but the Luxembourg representative, I don't know where he is, he told me, well, there's a nuance there, Steve, but he can tell me during the conference, perhaps. That goes for Luxembourg, Poland, and Romania. So they don't have any specific legislation on transfer of seat, but they do allow the transfer of the incoming transfer of seat from non-EU companies, by non-EU companies. The point that I wish to make here is that once a non-EU company transforms itself into an EU company, either by undergoing a legal merger or by transferring its registered office, further progress into the European legal area becomes a simple matter of making use of the CBM directive. The CBM directive makes the creation of a safe and well-guarded corporate law border of the EU as a whole as an unavoidable necessity, in my eyes. However, this in turn requires uniform and transparent national laws governing the inbound transfer of seat of non-EU companies and how local companies can merge with such companies. If any of these national laws are too permissive or not composed with sufficient care, the result could be a kind of sluice, using a metaphor, inviting non-EU corporate entities and interests to enter the EU without proper central control and oversight. With large numbers of fugitives from war and poverty heading towards the EU, protecting the EU's border has become a topical issue. In my view, it is also an important issue, a topic in connection with the CBM Directive. However, the EU's corporate law border does not follow the same line as its physical border. Since corporate law is an integral part of any member state's jurisdiction, of course, wherever its location in the EU. A chain is only as strong as its weakest link. I am not suggesting in the least that Cyprus is this weakest link. Forgive me if I ever give that impression. It could just as well be another member state. I simply do not know, nor am I aware of any policy, initiative, or awareness of the European Commission in relation to this issue. What I do know is that a swift adoption of a directive on the transfer of seat should be a matter of urgency, not only to harmonize the laws of the member states within the EU, but also to protect the EU's corporate law border from insufficiently controlled and undesired outside penetration. The status of being an EU corporate entity is something that should be preserved and not be acquired too easily. Therefore, in my view, one cannot adequately focus on the migration of companies within the EU without paying sufficient attention to their immigration into the EU. Which brings me to my second topic. Also has to do with protection, but then the protection of minority rights, minority shareholders involved in a cross-border merger. The CBM Directive sets out a wide array of rules and prescriptions to benefit minority shareholders in companies involved in cross-border mergers. In particular, those rules and prescriptions concern their right to be properly informed and consulted, the right to examine the documents drawn up by the company and the auditor involved, and last but not least, their right to challenge majority decisions on both the merger itself and the valuation of their shares. Yet, these are all general rules and principles that may be invoked by any shareholder. An exit right, a sell-out right, as it's sometimes called, conversely, is the only right connected specifically to the status of a minority shareholder. Does the CBM Directive grant minority shareholders a specific exit right? No, it does not. Strangely enough, in my eyes. Neither does the third EU directive on local legal mergers. Like the SE regulation, Article 4, the second section of the CBM Directive merely states that a member state may, in the case of companies participating in a cross-border merger and governed by its law, adopt provisions designed to ensure appropriate protection for minority shareholders who have opposed the cross-border merger. As a consequence, some member states have introduced an exit right in some form, could be withdrawal and cash compensation, a withdrawal of the outstanding shares, or a buyback obligation on the part of the merging company or the acquiring company or both companies, while other member states have nothing of the sort. So the CBM Directive does not prescribe an exit right for minority shareholders, and following an amendment adopted in 2009, Article 10, Section 3 of the Directive, I don't need a glass, I use the bottle. So the CBM Directive does not prescribe an exit right for minority shareholders, and following an amendment, it goes even further, adopted in 2009, in fact, the directive now discourages member states from introducing such right. That's odd, I think. A basic feature of the CBM Directive is that it demands compliance with the national laws on both sides of the transaction. So for both the disappearing, the merging company, and the acquiring company. before the merger can be effected. However, following this 2009 amendment, Article 10, Section 3 contains a fundamental exception to that rule. It inter alia states that, I quote, a procedure to compensate minority members, end of quote, in the law governing a merging company only applies if the other merging companies, quote, situated in member states which do not provide for such procedure, end of quote, explicitly agree to that procedure when approving the draft terms of merger. I really don't know how this could have been introduced into this directive, because I'm definitely opposed to this element. It means that even if the merger terms do not make any provision for this issue, the minority shareholders in the disappearing companies cannot invoke the exit right granted to them by their own legislator. This way, the European legislator simply brushes aside any initiative that a member state introduces in its own national law to provide adequate minority protection. Member state laws that do not offer this protection are given preference over protective law. I find that incomprehensible. I never studied the CBM directive in such details as the previous week, but I find this incomprehensible. I fear that in practice, this Article 10, Section 3 might work out as a kind of invitation to majority shareholders and their representatives in the board in a protective jurisdiction to form a cross-border merger with a special purpose vehicle in a non-protective jurisdiction. Because this would force, of course, the minority shareholders to choose between remaining in an unfamiliar legal environment or selling their shares below fair value. And I know it's not a theoretical exercise, what I'm sketching here. I'm looking at my good friend, Pavlos Masouros, and well, perhaps in your speech you can touch upon this topic as well. It is practice. It should be noted that a cross-border merger brings with it a fundamental change in legal environment for the shareholders, not only as regards corporate governance, but also in terms of settling legal disputes and corporate litigation, relationships with workers, unions, and other workers' representatives, when applicable, of course, the rules for challenging corporate resolutions, the role of notaries and other officials in corporate relations, etc. So obviously, this effect of what I call alienation from the company's legal environment will be stronger for shareholders of a closed, locally oriented company than for often foreign shareholders in a publicly listed company. Nevertheless, in my opinion, the minority shareholders' exit right in a cross-border merger is a fundamental right, should be recognized as a fundamental right. That should be recognized in the CBM directive, if not in the shareholders' right directive itself. That's what I wanted to tell you. Perhaps there are topics that will be touched upon and discussed during the conference. I hope so. I surely hope so. Perhaps I'm wrong. Perhaps I see it completely the wrong way. But anyway, I thank you for your attention, and I wish you all a great day and a smashing conference.